First one's easy. Go ahead and raise your right hand. Do you swear or affirm the testimony you're about to provide is true and accurate?
I do.
Thank you.
All right, ma'am. Please state your name.
Patricia Beyer, B-E-Y-E-R. I go by Patty, P-A-T-T-Y.
And ma'am, you, along with your husband and an entity, you have own land in Cherokee County that's being targeted by this proposed hazardous pipeline. Is that right?
Correct. And my husband and his sisters also have land in Iowa County.
Okay, different counties. And that's also being targeted?
Yes.
All right, very good. And you might just need to pull back just slightly from the microphone there. And so you caused to be pre-filed testimony along with attachments and exhibits in this matter. Is that correct?
Correct.
And do you have, with that testimony that you filed, any corrections or updates you believe are material?
I did bring some updates today that I've learned from testimony since I filed the pre-filed testimony.
And when you say learn from testimony, you mean you've learned from what Summit testified to that you weren't able to respond to initially?
Yes.
Okay.
Yes.
What's that?
I've learned that, excuse me, that there is a distance that's dangerous to live near the pipelines. So I put together a map of my neighborhood with these distances that have been discussed in testimony previously.
Okay. Is that something you'd like to be made into a hearing exhibit?
Yes.
All right. And along with, maybe we already have that. Wow, magic. Okay, while those are being passed out, do you have any other materials like that?
Yes, I also submitted a PHMSA letter today.
Okay.
That talks about rights of the states and the counties in terms of siting.
Okay. All right, and then anything else?
I also had a comment on water use that came up when the OCA gentleman was testifying.
Okay.
And that about wraps it up.
Okay. And the comment on the water use, is that something that's part of what's being passed out, or that's just a comment you need to make?
That would be a comment that I would have.
Okay. Just go ahead, and then we'll move on.
Go ahead with my water comment.
Yep.
I was listening to testimony by the OCA's Scott Bentz on September 13th of 2023. And that's when I found out that by signing an easement, I could be a party to affecting the amount and quality of water that will be available for humans and livestock in my area every year, forever. I find this disturbing. That affects the availability of water for consumption for all of us in the area of ethanol plants. Where will this water come from? How will it affect the availability for water for my uses and for my neighboring communities' uses? Where will the wastewater from the ethanol plant be discharged to? What contaminants will be included in the wastewater that's discharged from the ethanol plants? As it is my understanding, the triethylene glycol is used in the process of preparing CO2 for transport. Is this covert attempt under different names by Summit to secure water rights part of the need and necessity of that the IUB is committing Iowans to? It looks to me like we are being misled down the path to turning Iowa into a dangerous and toxic waste dump for the financial benefit of for-profit businesses. And as a taxpayer and a landowner, I can't believe this is happening.
And now to be clear, ma'am, you pre-filed testimony in your individual capacity along with your husband, and then your husband, Craig, separately filed testimony relative to his interest in the JCD Beyer Family Farm LLC. Is that correct?
That is correct.
Now, are you here today to talk specifically about the land you and he have together?
Yes, because I did not sign the testimony that he did for JCD.
Okay, and we'll be hearing from him later on that.
Yes.
All right, very good.
He was not able to make the able-bodied portion of the hearing this week.
Okay. All right, he can't physically be here.
Can't physically be here.
Right.
No.
I would then offer exhibits 38, 39, and 40, which are Ms. Beyer's pre-filed testimony and attachments.
Objections?
No objection, Your Honor.
And then we would further offer the two hearing exhibits that were handed out, one being a aerial map with some distances notated, and then a PHMSA letter.
Correct.
Objections?
No objection.
Seeing no objections, the board will give the way to.
And before I tender you, ma'am, the hearing exhibit, the map that you passed out, again, essentially that's you showing distances.
Mr. Jorde,
Yep.
we don't have numbers.
Oh, sorry.
Gotta keep them organized.
Yep, that's a good point. Let's make the Beyer hearing exhibit number 1 the map, the colored map, exhibit 621, please. And then if the PHMSA letter could be Beyer hearing exhibit 622. All right, so just briefly so we know what this is, 621, that's a map where you're showing distances to existing residences from the proposed pipeline in the area in proximity to your land.
Correct. For the last over a year, I have bugged my Summit land agents for plume modeling and safety data. And I finally received an email from the last agent, and he told me that plume reports are not available to anyone. They are retained by Homeland Security and are classified. They don't want terrorists getting that information. When I looked up Homeland Security, they're more concerned about electromagnetic pulses and that kind of terrorist activity. Not exactly the teenagers climbing over the fence to shoot a hole in a pipeline. But at the end of that email, excuse me, he said, remember, when you research, look at where the information originated. There's a lot of misinformation from questionable sources. And I'm thinking, duh, dude, you're sitting on this information. Why don't you give it to me? So we were left to our own devices to figure out how dangerous this thing would be, because clearly safety is an issue. So in listening to testimony, I heard that it could be 1,855 feet would be a really nasty place to be in a 8-inch pipeline diameter disaster. They have proposed a 12-inch pipe for my land, which would be exponentially larger than an 8-inch pipe. So, in a testimony earlier this week, I believe, there was a woman who testified whose son was a citizen scientist, and I believe he testified that up to 1.4 miles would be problematic, right around 7,300 feet. So I learned how to do Google Earth, which was a trip, and put together this map of property. It starts up with where my husband and I own land up there where it says Beyer, Iowa, IACK. Oh, I can't point to anything. And it goes down to the JCD property. Oh, here we go. Thank you. Okay, it starts here. And wait, let me look. Here, right there. Starts there, and it goes down to here. And these are the people north of us. So I figured out this was a 4-section section. And in that 4-section section, there are 17 landowner homes, or there's 17 people that live in that stretch, 17 homesteads. So then I went ahead and I calculated on Google Earth the distance that everybody was from this pipeline that runs northwest to southeast. In this stretch of these 17 homes, there are 2 homes that are under 500 feet. These people, right down in here, those people have the pipeline going about 473 feet from their home. Those people filed to be able to testify because they felt that their rights were being impinged on just a wee bit by being forced to be at the mercy of some other landowner to live with this kind of a disaster in front of their house. The people up here who are on the south end of our property, that property we used to own. That's where we raised our family, and then we moved down to this south farm right down in here, which is the home place. So this North Cherokee farm, these people are within, less than 700 feet. In the 500 to 1,000 range, there's 3 people, 3 families. In the 1,000 to 1,500 range, there are 4 families. In the 1,500 to 2,000 range, there are 2 families. When we go up to 2,000 to 2,500, there are 2 families. Those people are both at the mercy of their neighbors. They have no say in any of this. From a half mile to a mile, there's 3 families. 2 of them are at the mercy of their neighbors. And then we go out to a mile and a quarter, and there's 2 families. One of them is at the mercy of their family. The mercy of their neighbors. And right along here is Highway 59. And it's pretty heavily trafficked. And everybody that drives down this stretch of Highway 59, it's like driving by a cemetery. You hold your breath and hope you can get by there in one piece if something were to happen.
So just to recap, the numbers on here with the apostrophe, those are numbers of feet, and then the yellow pins indicate a homestead, correct?
Correct.
And then you have marked your land kind of in the center. It says buyer across it, and that's ground you own, and then you also, via the entity your husband's involved in, own ground in the lower right-hand corner, correct?
Correct.
Okay, good. I think we understand that.
Okay.
Excellent. I will tender you for cross-examination, ma'am.
Okay.
I don't see any placards up. I don't. Ms. Ryan?
Thank you. Good evening.
Hello there.
I wanted to ask you a little bit about your plans. So when you were pointing at the map, it looks like you live on maybe an acreage that's carved out of a parcel?
We live right, there.
Okay.
So we own this quarter here, right there. We don't have a pipeline going through that quarter. Our neighbor has a pipeline going across his quarter, so we're actually one of those people who are at the mercy of their neighbor. We own this parcel right here up in Cherokee County, and these people that bought our acreage are at our mercy.
Got it. Thank you. You indicated that the pipeline construction might impact your future living plans. How could it impact your living plans?
Well, I don't know why anybody would want to live near a hazardous liquid pipeline knowing the safety data. What little we know about the safety data, it's nuts. Why would anybody choose to live there? The other thing, too, is we get our income from rent on the land. You know, right up here on that KMZ map, on that KMZ map, the corner of the parcel that we own in Cherokee County, there's going to be a huge chunk across there that's just not going to produce for a very long time. There'll be a borehole under Highway 59 that'll just be destroyed and probably sit barren forever and ever and ever, longer than we'll even be able to be there. It pretty much just messes with everything that we've worked so hard to build up and live off of.
So I noticed that you also mentioned in your testimony that when you bought your land, it set a record high price for Ida County.
Yes, the land in Ida County ended up being a swap with a neighbor. If you can pull that KMZ up again. Further south, go down south. That's actually our property right there. A little more. Okay, right down here. Okay, our neighbor across the road, his family used to have all of this property. So probably 36 years ago, my husband's family picked up a quarter down in here. So about 2 years ago, this quarter came up for sale here. So the neighbor called us and said, if you want to buy that, he says, I'll give you X amount of dollars to swap me so that he could get the family land back. So he said, sure, because my husband says, his dad and I said to him, don't ever buy a crick farm, and then they bought a crick farm. So anyway, he was happy to get rid of the crick farm. And so then we swapped the neighbor for this piece of ground, and the neighbor was tickled pink to get that farm to put it back into the whole family thing. So yes, and it did set a record high for Ida County, which was like a heart attack for me. But anyway.
Are you concerned that construction of the pipeline would affect the property value?
Oh, absolutely. Absolutely. We spent an inordinate amount of time negotiating with our summit agents. At the behest of the utility board, actually, who said, you must negotiate in good faith with Summit. And when we first found out at that meeting in the fall of 2020, I believe it is now, 2021, I came home to my husband and said, I don't know what to think about this, but I skimmed through the literature and it said something about eminent domain, and I thought, well, that's probably not going to happen. So the first agent came, and probably that spring of 2022, and we said, well, we're not really interested in this. And she said, well, the company can do eminent domain here. You may want to look at this. And we went, well, geez, all right. So we thought, well, we better just find out what this is all about and keep an open mind and try to figure something out here. So we did. We probably met, in the last year and a half, we've probably met with Summit in person around our kitchen counter 7 times. And those meetings were about probably at least an hour, usually 2 hours long by the time they left. And when we got all done by this spring, and we'd finished our negotiations with Summit, this is what we had negotiated. We negotiated 60 inches of depth rather than 45 or 48. We will not have any above ground appurtenances, even though there were none scheduled for that piece of ground. And we got a trench plug. Okay. We also in that Exhibit C, it said that we didn't have to pay the money back if the project is not constructed. And actually, out of our 3 agents that we've had, the last 2 have said, you know, it may not go through, so you may want to take this money because it may not go through. And we'd go, well, you know, we're not in the business of taking money for something that we don't deliver on. That's just kind of not right. And actually, the last agent was using it kind of as a selling point, that if you take this money, you keep it. Gosh, this whole thing is not going to go anywhere. So, you know, it's your home free. And then everything else virtually on that Exhibit C was a restatement of the language in the original easement or in the Ag Mitigation Plan or in the 479B. Literally, we got 4 things. Okay, then there was the flat out no part of negotiating with Summit. We started out with a 10-inch pipeline, and next thing we knew, it was a 12-inch pipeline. So we went through the easement one meeting, and I said to the guy, well, you know, on the Exhibit at C, it says, notwithstanding the diameter stated in Section 1A of the easement agreement, and then it went blah, 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 the pipeline shall not exceed 12 inches in nominal diameter. And I said, let's just take that notwithstanding part out, and then we can just get down to the pipeline shall not exceed 12 inches in nominal diameter, because it doesn't get any more clear than that. No. I said, well, okay, no, that's just not right. Another big sticker was a forever, ever pipeline easement. And I said, gotta have something less than forever. I said, my understanding at that time was that North Dakota had a 50-year easement. And the guy said, no, Summit's only doing permanent easements. That's all the easements they'll do. And I said, well, I'm pretty sure I heard that there was lesser easements in other states. Well, when I looked it up, it was like North Dakota was 99 years and then 50 years for a water area easement. So there's no reason why they can't do less than a permanent easement. And like I said before, I started asking for plume modeling way a long time ago, and they just kept putting us off. Some of the other stuff we asked for was damage to the remainder, because it's going to screw up all the ground there in that farm, because it cuts diagonally across the farm, it cuts across terraces, it cuts across everything. And the guy said, oh, no, we're not doing damage to the remainder. He says, and I quote, all the carbon dioxide is going to do is turn the property green. And I'm thinking, yeah, and the people too, but seriously. We asked for most favored nation status. And the one agent didn't seem to know what that was. And I'm thinking, well, they're sending these guys out pretty darn untrained. I don't know who wouldn't know that if you were an agent for a company. And he said, no, company doesn't want to get involved in most favored nation. We said, well, we probably need to spell out in the Exhibit C that the landowner has the right or the option to have the company remove the pipe at the company's expense when the easement is returned. Now, I know it's mentioned in 479B, but my impression was that it needed probably to be included in an easement. So that was the stuff they refused to negotiate on. Well, what else was there? Oh, I asked about the landowner having to pay legal fees if the company doesn't do what they say they're going to do. Company said, we do not pay legal fees, nor do we have any prevailing party language. I also asked them if they would have an escrow account in case the company went belly up or abandon the pipeline for some reason. Everybody's left holding the bags. It's not something you want to leave the taxpayers with, because, heck, an LLC can just pack up and leave, and everybody else is just dead in the water then. So anyway, so that's the stuff they refused to negotiate on. And then these are the ones that they never got back to us on. Will Summit include us as additional insured on their policy? Don't know. Is Summit going to provide neighbors with CO2 detectors or scuba equipment or something, some kind of safety equipment? Is Summit going to provide safety equipment for my fire department and my sheriff? And if not, then the taxpayers are going to pick up that tab. That's an additional cost to the taxpayers. I said, is Summit coming back in the next 10 years, every year, to pick up rocks from the easement area? I've picked up rocks. I don't want to pick up rocks after Summit every year. Will Summit pay for damage to the combine when a rock runs through it? Nope. Is there a cutoff valve on either side of Highway 59? How will I be notified of a pipeline break? If the notification system fails, who's responsible? Who do we sue? If the company decides to increase the size of the pipe after the easement is signed, will there be additional compensation? No, never, no information. So then I get the postcard from the IUB, and we're still trying to make this work. And it said, return this postcard to say if you're interested in mediation. Well, I never heard back on that. It could be because I said I'd be interested in mediation if Summit was willing to negotiate an easement with limited number of years, yearly right-of-way payments to the landowner for as long as the pipe was in the ground, changing the route across the land, which I can get to later, damage to the remainder of the property payment, removal of all landowner liability. I did find out in my insurance in the last probably couple weeks that if I sign an easement to allow a pipeline on my property, I could be liable for damages.
Your Honor, I'm going to object. This is just a lengthy monologue that is simply supplemental direct testimony. Almost all these issues were known or knowable prior to the July 24th deadline. This is just an extensive supplement to the pre-filed direct. It's not related particularly to any specific question. It's procedurally inappropriate. We object.
Okay, I don't know who wants to respond to that. Ms. Ranch, your question is, or Mr. Jorde, it's your client, so.
I can ask a specific question at this point in time.
Great, thank you.
You indicated that you proposed an alternate route for the pipeline. Can you show us what that alternate route would have been?
I sure can. Okay. So my first proposal to them was to go along this line, right, along the north side of the property, and then come down here, and as soon as possible, shoot across the highway. My concern is that I don't want to be the person who signs a death warrant for these people. And there's another place over here, and the difference between them is like 2,500 feet. These people don't have a chance. Of course, these people don't have a chance either to survive any kind of a pipeline break here. But I first proposed coming over here and then going down there and then shooting across. These people have already signed for an easement. The construction engineer told me that would add 1,300 feet, and that was too much money, and the company was not going to do that. So I said, okay. So a couple months go by, and we're talking to the agent again, and I say, how about this? How about you just shoot straight across there, and then you can just skirt this fence line all the way down. These people don't mind having a pipeline apparently on their property. How about we do that? Well, I think it was Mr. Skovanec who, when board member Burns had that list of 40 people that he was showing KMZ maps to, Mr. Skovanec said, no, can't do that. That's not going to work. So, I don't really know what to say. It was just baloney.
If the pipeline were moved to go east to west across the northern edge of this parcel, would it be less damaging to your farmland?
Yeah, we have terraces there. And as numerous people have said, it looks like we're cutting through pretty much every single terrace that we've got there. And when my husband's family bought this farm back in the 60s, it was a highly erodible farm. So they put in terracing, they did conservation tillage things, they did all kinds of stuff to bring this farm up to high production. And they've successfully done that. So last spring we put in French drains in here. We took out standpipes, put in French drains. And by running this thing through there, that's pretty much going to destroy those French drains and their ability to drain stuff. You blow on a terrace and you've got trouble for a very, very long time.
And but there would be less of that kind of impact across the north or south, going east to west along the northern border?
Yes, there would be much less impact along here. Our first choice is not to have this, period. I don't want the liability. It's an insane amount of liability. It's for Summit, it's high reward, low risk. For landowners, it's high risk and no reward. Because everything you would make, you would spend fouling around fixing up stuff that Summit screwed up.
Thank you. That's all my questions.
Okay, seeing no more questions, Mr. Jorde for redirect.
Yes, thanks. Can we go back to 621 for a moment, please? And I just want to be clear for the record, where's the dividing line, if you know, between Cherokee and Ida County?
It is right down, right here. This is the dividing line.
Okay, can we just zoom in on that? I just want to see if we have a road.
Okay, that's CB. That CB dot is where we live right there.
Okay, by the CB.
That's, yeah, we live right in here.
2348, that's where you live, and you live right on the county line.
Yeah, we live on the county line. So we're 2348 away from this pipeline. I'll look out the kitchen window at it.
All right, and thank you. That's all I wanted on that. And then you said that you thought someone was almost using as a sales pitch or a selling tactic the fact that this project may never come into existence.
Absolutely. Absolutely.
And did you feel like that was kind of reverse psychology? If they say that to enough people and they get it, then they can march into the IUB and say, see, everybody wants it. Now give it to us.
Absolutely. And for whatever reason, people bit. Yeah, it's quite a sales pitch. Here's free money. Take it. I won't go through.
Then in terms of your negotiations, you referenced that in your, at least discussions, they would kind of cross-reference to 479B or some existing laws for certain conditions. Is that what you were getting at?
No, they never reference 479B. I reference 479B because when they gave us this stuff, I would go back through and see how different that was than 479B or the ag mitigation plan. It's the same thing. It's on an Exhibit C, but it's the same thing that's already been stated in the other stuff.
And when you referenced the concept of most favored nation status, which Summit rejected, that is a way of saying if they negotiate something superior, better terms, better protections with someone else, that you would also get those.
Correct.
Okay. But they didn't agree to that.
No.
Do you think if this were for some reason approved by this board, would you think that a restriction on the easement time would be appropriate?
You mean like a finite number of years?
Yeah, like...
Oh, absolutely. I've said to our agents, I said, this is a 12-year project. And it's a project that's never been done. Summit has yet to move 1 liter of product through any kind of a pipeline. We don't even know if the thing is going to work. Why don't you start with 1 plant and see what happens from there? I mean, this is like taking the Oregon Trail back 200 years ago and putting an interstate highway on it. There is no... I mean, it's... To back up a bit, this is like going from 0 to DEFCON 1 in one fell swoop. This is ridiculous. We don't know if 1 plant will do it, let alone 12 plants will do it. And in the meantime, they're going to destroy all this land and hope for the best, or, I don't know, claim that they've sequestered stuff, but we don't know if they can or not.
So on your, again, proposed reroute, which is not something you want to happen, but if for some reason this was approved on your property, you had talked that I guess you recited that Mr. Skovanec, and then in your prior discussions, they said they can't or they couldn't do that. Is that right?
Yes.
But did you come to understand that it's actually we won't and we don't want to, not that we can't?
Yes. It became very obvious that it was about money. They didn't want to spend any more money to do that. Too expensive. Too late. The other excuse was, it's too late to change. I mean, this was like, man, when did we start talking about this? It would have been last fall, early. Might have been last fall. They said, too late to change. I said, my gosh, you just started this thing. We've only known about it for probably less than a year, and you're telling me it's too late to change stuff? Mind blown.
Do you feel like that's an excuse to try to penalize you for not signing on yet?
Absolutely. Absolutely. I've had to make a lot of consequential decisions, probably in the last 30 years of my life. And I've stewed and I've sweated and I've made these decisions and I've always felt good about them. But I have to say, this is the first time in my life where I've ever had to, or been forced to possibly, sign a document that will cause the death of people that I know. I have never signed a document that intentionally caused damage or harm to somebody else. But the signing of this document is absolutely immoral and unethical. We sat through all these meetings with these people, and we tried to figure out a way that this might work. And there's a big pot of money out there, but we can't sleep at night knowing that we have purposely, for money, placed other people's lives on the line. It's kind of a big deal. May not seem like a big deal to other people. It's a big deal to us.
Thank you. I don't have anything further.
Thank you.
Thank
You're
you.
excused.
Thank you.
Okay. We will plan on being back Tuesday. We don't have names, but we'll plan on having Mr. Jorde's witnesses, and if we get a sense of who will be up Tuesday, great, knowing that it'll be in flux. We'll continue to try to iron out some scheduling details and get to the parties as quickly as we can. I think actually Mr. Dublinsky had his light up first.
Yes, just I understand that there may be some things in flux, but Mr. Jorde did sound earlier like he had identified 4 or 5 people that would likely be here in person, 5 people that would be here on video. You know, we certainly tried when we were having to shift and adjust to give notice the day, the end of the session before. If Mr. Jorde knows those people, understanding that may be a bit in flux, but if we can get a sense of those names, that will help things move faster because we can prepare.
Right. And even if it's just, I assume, because we're in the same boat, a sense of, if we can get, if they need to move around, if we can just get an idea of who's up next week and go from there. So, but it sounds like we're all on the same page there, Mr. Jorde.
Yeah, and I'm happy to do that. I mean, rather than reading off the names now, I mean, if it's okay, I could make a filing tomorrow, and I'll put the names of the people that I think can make it. Again, appreciating that if we can kind of weave and bob a bit, that would be good. But I mean, I will certainly release all the names of the people if that's acceptable.
I think that'd be wonderful.
We would certainly appreciate that. And I agree. A filing's easier than reading them all off.
Okay. If the bandwagon grows on Monday, you file again with more names.
Okay. Well, we'll try. We'll try to keep getting folks. And then Mr. Dublinsky did file that stipulation as to pre-filed testimony that they were waiving cross-examination on, and then the entry of those exhibits. I realized that was a one-way stipulation. I think board chair did ask at that time if anyone else had objections, and I don't think there were any objections. But I just wanted to be absolutely clear. So what I'd like to do is read the exhibits into the record and just have it clear that they have been received officially, as opposed to just a stipulation. I don't know if the stipulation is suitable to actually trigger the receipt, but I'm happy to be corrected.
I just want to double check. There was no objections? Mr. Taylor, did you have objections?
I think I did.
I thought so. Look at that, I remembered. Do you want to maintain the objection?
But just to clarify, okay. I remember Mr. Taylor objected to Summit's unilateral representation with regard to landowners when we said that, if we can finish next week, we wouldn't have any objection to virtual, and that, but we would suggest that after all those slots had been offered, the people that didn't take them, we would stipulate their testimony and exhibits in, and they simply would not, the hearing would end and they wouldn't testify if they did not avail themselves of a slot next week. That is a different thing than what Mr. Jorde is talking about that he and I stipulated to, which involves the non-landowner witnesses, basically the Jorde landowners expert, for lack of a better word, witnesses. There were about 20 of them, and we had filed a stipulation. We had represented in that we had conferred with Mr. Jorde and he had no objection. I don't think it's going to take long for him to read the exhibits, but they are in the filing, and I think if he simply says on the record, yeah, the stipulation is, mutual, we agree to it, the numbers shown for exhibits are correct, I think that should suffice. But I don't want to speak for Mr. Taylor. I just want to clarify there are 2 different things, and I remember him objecting to one but not the other.
Mr. Taylor?
Thank you. I know that the stipulation was filed. I haven't had a chance to look at it yet. Let me look at it tomorrow, and I'll file something in response.
Thank you. Before we get going too far, but Ms. Ryan, did you have an objection to this stipulation? I know you had an objection last week, or when we had initially talked about a stipulation between Summit and Jorde, but I wasn't clear if it was this one or if it was a different one.
It was not this one.
Okay, thank you. Okay, everybody get along.
Yep. And so I would just add to that, assuming Mr. Taylor doesn't have an objection, I will next week, or Christian, whomever can be here, will simply request that the board acknowledges it on the record and it affirms that all of the exhibits specifically listed in the stipulation are received into evidence.
Okay. I think we can work through this, and I appreciate everybody working together on that, and go from there. Did you have one more thing?
I did have one more thing. I just, again, for the record, I just wanted to note for the record that yesterday, Wednesday, that board member Martz was not physically present here until approximately 3:30 p.m. and that today, board member Burns left at approximately 3:30 p.m.
Okie dokie. Have a good weekend. We'll see you at 8 a.m. Tuesday.